Case 1. Sister Mary Margaret Kruper. St. James Catholic School, Torrance, California. For 28 years, she ran a Catholic elementary school. Parents trusted her. Students respected her. The Archdiocese gave her complete control over finances, tuition payments, and charitable donations. Then, the year she retired, auditors opened the books. What they found would result in a federal conviction, a prison sentence, and the return of over $800,000 to the community that had trusted her for nearly 3 decades. Case 1. Sister Mary Margaret Kruper. Mary Margaret Kruper entered the Sisters of St. Joseph of Carondelet at age 18, approximately in the year 1960. Her religious order is headquartered in St. Louis, Missouri, and has operated Catholic schools across the United States for generations. Kruper was assigned to St. James Catholic School in Torrance, California, a kindergarten through 8th grade parish school operated under the Archdiocese of Los Angeles, where she served as principal for approximately 28 years, beginning around 1990. Annual tuition at St. James ran approximately $6,000 per student. Kruper had signature authority over school financial accounts, held the trust of the parish pastor, Monsignor Michael Myers, and submitted monthly and annual financial reports to archdiocesan administrators. No one questioned her. There was no independent audit protocol, no dual signature requirement, no separation of duties. For nearly 3 decades, one person controlled the money, and that person was Kruper. According to federal prosecutors, the scheme began approximately in the year 2008. Over the following 10 years, through September 2018, Kruper diverted tuition checks, fees, and charitable donations intended for the school into unauthorized bank accounts she controlled. She used an endorsement stamp reading St. James Convent rather than a St. James School, redirecting funds into the St. James Convent account and the St. James Savings account, accounts that school administrators did not know remained active. She falsified monthly and annual financial reports submitted to the Archdiocese. She created records that did not reflect actual transactions. And when a routine financial review was eventually triggered by her retirement, she directed school employees to alter and destroy financial records rather than submit them to the auditors. The funds were used to finance extended gambling trips to casinos in Las Vegas, Lake Tahoe, and Temecula, California, as well as personal travel, dining, and credit card charges. While parents were told there was no money for an awning at school and no money for field trips, Kruper was drawing from school accounts to fund her casino visits. The investigation was triggered in June 2018 when Kruper retired and the Archdiocese initiated a routine financial review. Auditors noticed irregularities. Kruper became visibly anxious about the review process, according to Monsignor Myers, and instructed staff to change certain records. Those staff members reported her instructions to school administrators rather than complying. The Archdiocese then retained an independent forensic auditor. The forensic review initially examined 6 years of bank records. As the scope expanded to 10 years, the total confirmed loss grew to $835,339. On November 28, 2018, Monsignor Myers sent a letter to parents disclosing the embezzlement. The Archdiocese initially stated it did not wish to pursue criminal proceedings. Under sustained pressure from parents and local media, the Archdiocese filed a criminal complaint with the Torrance Police Department. The FBI and the IRS Criminal Investigation Division joined the investigation. Search warrants were executed at the sisters' residence in February 2019, and computers and bank statements were seized. Federal charges were filed in the United States District Court for the Central District of California on June 8, 2021. Kruper was charged with 1 count of wire fraud under Title 18 of the United States Code, Section 1343, and 1 count of money laundering under Section 1956. The combined maximum penalty for both charges was 40 years in federal prison. The case was prosecuted by Assistant United States Attorney Poonam G. Kumar of the Major Fraud Section. Kruper was represented by defense attorneys Mark A. Byrne and Daniel V. Nixon. Federal charges were filed by criminal information rather than grand jury indictment, a standard procedure in cases where a plea agreement has been pre-negotiated. Kruper formally pleaded guilty to both counts on July 1, 2021. No trial was held. Sentencing took place February 7, 2022, before United States District Judge Otis D. Wright II, conducted via video teleconference. Prosecutors sought a sentence of 24 months. The defense submitted letters of support from more than 200 individuals, including former students, parents, and community members who spoke to Kruper's decades of educational service. Several former students, however, wrote letters opposing leniency, stating the theft had contributed to their departure from the Catholic Church. Judge Wright imposed a sentence of 12 months and 1 day in federal prison, 366 days, along with $825,338.57 in restitution to the school. She had already returned $10,000, a $200 special assessment, 2 years of supervised release, and mandatory gambling addiction counseling. She was ordered to surrender to federal custody by June 7, 2022. In court, Kruper stated, "I have sinned, I have broken the law, and I have no excuses. My actions were in violation of my vows, my commandments, the law, and above all, the sacred trust that so many had placed in me." Judge Wright stated from the bench, "Somewhere along the line, you just ran completely off the road." He acknowledged her decades of service, but noted the magnitude of the financial betrayal and addressed her directly, asking how she could feel financially strained given that she had effectively signed on to be poor as a vow of religious poverty, while simultaneously directing $835,000 of school money to personal use. Prosecutor Kumar stated, "That is an outpouring of greed. She abused the trust of this community." Kumar further noted that, on an annualized basis, she stole the equivalent of the tuition of 14 different students per year. Former school secretary Cheryl Hugo testified at sentencing that it was an abuse of power in every possible way. A former student indicated the experience played a role in her no longer being a part of the Catholic Church. One parent, Kevin Kearns, submitted a letter in support of Kruper, stating that despite the theft, he got exactly what I paid for, as a parent who valued the education his children received. A second individual named in connection with the case, Sister Lana Chong, a teacher and vice principal at St. James for approximately 20 years and Kruper's close friend and roommate, was initially implicated in the November 2018 disclosure. Both women were removed from ministry and placed under canonical restrictions by their order. However, Chong was never criminally charged. The U.S. Attorney's Office confirmed in June 2021 that only Kruper was charged and that the investigation was considered closed. Kruper accepted sole criminal responsibility for the full $835,339. No appeal of the conviction or sentence was filed. Kruper surrendered to federal custody and served her sentence. The case prompted a review of financial control protocols across archdiocesan schools and drew national attention to the absence of independent oversight in religious educational institutions. The total financial loss, $835,339, diverted over 10 years from an elementary school community, stands as the largest documented embezzlement conviction against a Catholic nun in United States legal history. Case 2. Sister Marie Thornton. Iona College, New Rochelle, New York. She ran the finances of an entire college. For 10 years, she submitted false invoices, charged personal casino trips to institutional accounts, and manipulated the books of a Catholic institution that received federal funding. By the time investigators finished, the total exceeded $850,000. The college never called police. The crime was uncovered by a journalist reviewing a tax filing. Case 2. Sister Marie Thornton. Marie E. Thornton, known within her community as Sister Marie Thornton and informally referred to as Sister Susie, was a member of the Congregation of the Sisters of St. Joseph, headquartered near Philadelphia, Pennsylvania. She served as Vice President of Finance at Iona College in New Rochelle, Westchester County, New York, a Catholic institution founded in 1940 and operated by the Irish Christian Brothers. She held a position functionally equivalent to Chief Financial Officer. She handled all day-to-day finances, maintained relationships with external auditors and contractors, oversaw bank accounts, and approved expenditures. At the time of the offenses, Iona College enrolled approximately 4,200 students with annual tuition of approximately $28,000. The college received federal funding, which brought its financial activities under federal criminal jurisdiction. Thornton's position gave her unchecked authority over institutional funds, with college president Brother James A. Ligori focused primarily on external relations and institutional development. According to federal investigators with the U.S. Department of Education, Office of Inspector General, Thornton executed her scheme through 4 documented methods over approximately 10 years from 1999 through May 2009. She submitted false vendor invoices for reimbursement, drawing college funds for services or goods the institution never received. She submitted personal credit card bills for payment by the college, billing the institution for personal charges. She used an institutional credit card for personal purchases, including gambling-related travel expenses. And she wrote college checks for her own direct financial benefit, falsifying records to conceal the transactions. Federal prosecutors stated the confirmed total exceeded $850,000. Iona College's own internal accounting cited $800,000. Early media reports suggested the total could have approached $1,200,000. The money funded a gambling addiction that included frequent trips to Atlantic City, New Jersey, casinos, where she primarily played slot machines. Former Iona men's basketball coach Jeff Ruland publicly confirmed that Thornton definitely had a gambling problem. On May 26, 2009, college president Brother James Ligori discovered the misappropriation during what was described as a routine administrative review. Thornton and a subordinate who had approved purchases at her direction were fired. The college publicly stated Thornton had departed for medical reasons. Iona retained forensic accountants who conducted a 6-month financial review. At no point did the college report the matter to law enforcement or the Westchester County District Attorney's Office, which later confirmed it received no complaint from Iona. The crime became public knowledge only in October 2010, when journalist Andrea Fuller of the Chronicle of Higher Education, conducting a review of Iona's 2008 IRS tax filing, a Form 990, which is publicly available, discovered a supplemental report disclosing the financial irregularity. Blogger Robert Cox of Talk of the Sound subsequently identified Thornton by name and publicized the case in detail. The U.S. Department of Education, Office of Inspector General, then opened a federal investigation. Because Iona received federal funding, the offense fell under the federal embezzlement statute governing organizations that receive federal funding, codified at Title 18 of the United States Code, Section 666. Federal charges were filed in the United States District Court for the Southern District of New York. The case was prosecuted by the Office of U.S. Attorney Preet Bharara, with Assistant United States Attorney Carrie H. Cohen of the Public Corruption Unit handling the matter. Thornton was arrested and arraigned December 9, 2010, and entered an initial plea of not guilty. She was released without bail. Her defense attorney was Sanford Talkin. On March 9, 2011, Thornton pleaded guilty to 1 count of embezzlement from an organization receiving federal funds before U.S. Magistrate Judge Kevin N. Fox. The offense carried a maximum penalty of 10 years in federal prison and a $250,000 fine. Sentencing was conducted November 8, 2011, before United States District Judge Kimba M. Wood. Prosecutors sought a sentence of 3 years in federal prison. Judge Wood imposed a sentence of time served, no additional incarceration, along with 3 years of supervised release, 2,000 hours of community service, $350,000 in restitution, and a $100 special assessment. The restitution figure reflected the amount remaining after Iona's insurance carrier had recovered approximately $500,000. Given Thornton's vow of religious poverty, full repayment of the remaining amount was widely regarded as unlikely. U.S. Attorney Bharara stated at the time of the arrest, "This is a classic case of the fox guarding the henhouse." Marie Thornton was entrusted with the financial well-being of Iona College, but instead, she abused her access to cook the books and line her own pockets. At sentencing, Thornton stated, "I'm sorry I hurt so many people I genuinely loved. I'm sorry for embarrassing my religious community, my family, and my friends." Her attorney attributed her conduct to what he described as childhood demons that fueled the gambling addiction. Following sentencing, Thornton was placed in an isolated residence at a Philadelphia convent of the Sisters of St. Joseph, where her activities, access, and responsibilities were described as totally restricted. No appeal was filed. The case drew national attention not only because of the scale of the theft, but because of the institutional response, or absence of one. The college had a federally mandated obligation to maintain financial controls over grant-funded and federally supported programs, yet it neither reported the crime to law enforcement nor alerted the U.S. Department of Education. The crime was discovered not through institutional disclosure, but through a journalist reading a tax form. It took 15 months from discovery to public knowledge, and even then, the disclosure was accidental. Iona's president subsequently acknowledged the institution had failed to self-report. The case prompted policy discussions among Catholic college administrators about mandatory reporting obligations, financial oversight structures, and the risks created when a single individual exercises unchecked authority over institutional finances, regardless of their religious title or vow of poverty. Case 3. Sister Barbara Markey. Archdiocese of Omaha, Nebraska. She was nationally recognized. She co-created a marriage preparation tool used in dioceses across 13 countries. She was trusted with the finances of an archdiocesan family life office she had founded herself. Then an internal audit found over $300,000 unaccounted for. When the case reached court, the judge refused to grant probation, and she was handcuffed in the courtroom. Case 3. Sister Barbara Markey. Sister Barbara Markey was a member of the School Sisters of Notre Dame, one of the largest Catholic women's religious orders in the United States. She served as the founding director of the Omaha Archdiocesan Family Life Office, appointed by Archbishop Daniel E. Sheehan in 1978. In that capacity, she held both administrative and clinical responsibilities. She was a licensed clinical psychologist, and she was the co-creator of the FOCUS inventory, facilitating open couple communication, understanding, and study, a nationally and internationally respected marriage preparation questionnaire used in diocesan programs across the United States and in 13 other countries, generating substantial revenue for the archdiocese. The copyright for the FOCUS inventory was held by the Archdiocese of Omaha, not by Markey personally. Markey's position gave her broad control over the finances of the Family Life Office, including its budget, disbursements, and accounts. For more than 2 decades, she operated with limited oversight. No independent annual audit was required. No dual signature requirement governed expenditures. No external financial controls were applied. The archdiocese trusted her and the office she had built. In 2004, following concerns raised internally, the archdiocese conducted a financial audit of the Family Life Office. The audit identified $307,545 in missing or undocumented funds. Investigators subsequently established that the confirmed embezzlement total exceeded $250,000. At least $76,000 was traced to cash advances used at the Ameristar Casino Hotel in Council Bluffs, Iowa, a riverboat casino on the Missouri River directly across from Omaha. An additional $80,000 was traced to unaccounted cash withdrawals. Funds were also found to have been used in the purchase of a personal condominium in Colorado. The archdiocese itself initially claimed the total could have reached $800,000, though an IRS audit did not corroborate the higher figure. The confirmed criminal charge was based on the legally established amount. Markey was fired in January 2006. The Archdiocese of Omaha filed a civil lawsuit seeking $820,000. The case was also referred to the Douglas County Attorney's Office for criminal prosecution. In Douglas County District Court in Omaha, Nebraska, Markey was charged with 1 felony count of theft by deception involving an amount greater than $1,500, the threshold for felony classification under Nebraska law. The charge carried a maximum penalty of 20 years in state prison. On March 31, 2008, at 73 years of age, Markey entered a guilty plea. Under the plea arrangement, both prosecutors and defense counsel agreed they would not oppose a sentence of probation. Markey agreed to pay $125,000 in restitution, and the Archdiocese agreed to dismiss all civil claims. The sentencing was expected to result in probation consistent with the agreed terms. Sentencing occurred July 11, 2008, before Douglas County District Judge Thomas Otepka. In a development that neither side had anticipated, Judge Otepka imposed a sentence of 3 to 5 years in the Nebraska Department of Corrections, reduced to an effective range of 18 to 30 months under applicable sentencing guidelines. Markey was taken into custody immediately in the courtroom. Judge Otepka stated from the bench that a sentence of probation would have depreciated the seriousness of the crime and promoted disrespect of the law. He declined to accept the argument that the offense was a momentary flaw caused by a gambling compulsion in an otherwise exemplary life. Douglas County Attorney Don Klein described the sentence as an appropriate sentence that sends a signal that when people steal that amount of money, they need to be held responsible. Defense Attorney J. William Gallup stated publicly that the outcome was a terrible decision and that Markey was shocked and disappointed by the judge's departure from the agreed recommendation. Following sentencing, Markey filed a motion seeking to withdraw her guilty plea. Her defense argued that priests in similar circumstances had received sentences of probation, suggesting an unequal application of sentencing standards based on the defendant's gender and religious status. Judge Otepka denied the motion, ruling that sentencing authority rested solely with the court and that the withdrawal request came too late in the process to be granted. Markey was subsequently paroled at age 75. Conditions of her parole included a prohibition on entering any casino. She returned to her religious community following release. The Archdiocese's civil claims were resolved as part of the original plea arrangement. The Markey case is significant in the documented history of Catholic institutional financial crimes for several reasons. It involved not a school, but an archdiocesan program office, a department responsible for marriage and family ministry rather than direct educational operations. It involved a nationally recognized professional whose work was used in more than 13 countries. The funds were diverted through a series of financial mechanisms over an extended period, and the discovery came through an internal audit triggered by internal concerns, not by an external audit, a journalist, or law enforcement referral. And it resulted in one of the more substantial prison sentences imposed in documented Catholic institutional embezzlement cases. Case 4. Sister Mary and Rapp. St. Mark's and St. Mary's parishes, Holly and Kendall, New York. For over 20 years, she was a trusted figure at 2 parish communities in western New York. Then a routine archdiocesan audit found over $100,000 missing from weekly collection proceeds. The money had been going to a casino in Niagara Falls. She pleaded guilty to grand larceny. Case 4. Sister Mary and Rapp. Sister Mary and Rapp was a member of the Sisters of St. Francis of Penance and Christian Charity, a Catholic women's religious order. She served at 2 parishes in the Diocese of Buffalo in western New York, St. Mark's Parish in Holly, New York, and St. Mary's Parish in Kendall, New York. She held her assignment at these 2 communities for more than 20 years and was 68 years old at the time of sentencing. Over approximately 5 years, from 2006 through 2011, Rapp diverted approximately $128,000 from the 2 parishes. According to the criminal proceedings, she removed cash from weekly collection plate proceeds and deposited checks intended for the parishes into her personal bank account. The funds were directed to a gambling habit she had developed at the Seneca Niagara Casino in Niagara Falls, New York. The scheme was not discovered through a complaint or a tip. It was identified through a diocesan financial audit conducted in the fall of 2010 as part of routine oversight procedures. The audit identified the financial irregularities in both parishes. Rapp was placed on administrative leave in February 2011 and terminated from her position at the parishes in April 2011. Criminal charges were filed in Orleans County Court in November 2012. She was charged with grand larceny, the appropriate New York State felony charge for the theft of funds in that amount. Rapp entered a guilty plea in April 2013, acknowledging responsibility for the theft. Sentencing was conducted July 8, 2013. The court imposed 90 days in the Orleans County Jail, 5 years of probation, 100 hours of community service, and full restitution. Her religious order offered to contribute $10,000 per year toward restitution for each year of probation. Defense counsel noted at sentencing that Rapp, as a woman religious who had taken a vow of poverty, held no personal assets beyond those of her order. The full amount was accordingly regarded as unlikely to be repaid through her personal resources alone. No appeal was filed. The rap case illustrates several characteristics common to financially related criminal cases involving women in religious life. The theft occurred over a 5-year period at 2 separate parishes, suggesting a pattern of conduct rather than an isolated incident. The method, removing cash from collection proceeds and redirecting deposit checks to personal accounts, exploited the informal financial controls common in small parish settings, where cash handling procedures often lack the rigor of commercial or institutional finance operations. Detection came through a diocese-level audit rather than parish-level observation, suggesting that local community members, fellow parish workers, and church administrators had not identified the losses. The gambling addiction element ties the rap case directly to the other documented financial crime cases involving women religious in the United States. In every documented case of embezzlement by a Catholic nun resulting in a criminal conviction, Crooper in California, Thornton in New York, Markey in Nebraska, the financial motive was the same: a compulsive gambling habit funded through theft from a trusted institutional position. Casinos in each case were the destination: Las Vegas and Lake Tahoe for Crooper, Atlantic City for Thornton, Council Bluffs for Markey, and Niagara Falls for Rapp. All 4 women held positions of sole or near-sole financial authority. All 4 were discovered through audits triggered by departure or routine oversight rather than proactive detection. And in all 4 cases, the Catholic institution involved either delayed or entirely avoided self-reporting to law enforcement, relying on internal processes until external pressure, public disclosure, or investigative authority compelled criminal prosecution. The Diocese of Buffalo subsequently conducted additional financial reviews of parish accounts across the diocese following the rap case and implemented enhanced audit protocols for parish-level financial operations, including more frequent external reviews and dual signature requirements for accounts above defined thresholds. Case 5. Sister Norma Giannini. St. Patrick's Elementary School, Milwaukee, Wisconsin. She was a teacher and principal. For the men who came forward 40 years later, the memories had never faded. The case should have been impossible to prosecute. The events happened in the 1960s, and Wisconsin's statute of limitations had long since passed. Then a detective found an obscure legal provision that changed everything. Case 5. Sister Norma Giannini. Sister Norma Giannini was a member of the Religious Sisters of Mercy, abbreviated RSM, one of the largest Catholic women's religious orders in the world. She was born in Chicago, Illinois, and entered the convent at age 18 in 1946. She was assigned to St. Patrick's Elementary School on Milwaukee's near South Side, where she served as an 8th-grade teacher and subsequently as principal from 1964 to 1969. She was also designated as a Mother Superior, a supervisory role within the convent attached to the school. Court proceedings established that during her time at St. Patrick's, Giannini committed sexual abuse against multiple minor students. 2 male victims, Gerald Cobbs and a second individual identified in court proceedings as James St. Patrick, became the basis for criminal charges. Court evidence established that Cobbs was 13 years old when the abuse began in 1965 and that he experienced between 60 and 80 incidents of abuse. The second victim experienced more than 100 incidents beginning in 7th grade. Both individuals reported ongoing patterns of conduct over multiple school years. A psychological assessment submitted to the court found that Giannini had selected her victims based on family vulnerability, specifically identifying children from households with absent fathers due to abandonment, substance dependency, or incarceration. The assessment characterized the selection pattern as deliberate. In 1992, one of the Milwaukee victims contacted the Sisters of Mercy directly. The order removed Giannini from her position as principal at Most Holy Redeemer School in Evergreen Park, Illinois. No criminal report was made to law enforcement at that time. Parents and school communities were not informed of the reason for her removal. Around 1996, Giannini appeared before a Milwaukee Archdiocese review panel designated as Project Benjamin, established to evaluate historic allegations of misconduct by clergy and religious staff. During that appearance, she was interviewed by a psychologist named Pius Secchi and, according to court records, acknowledged conduct with students. When asked by the psychologist what the children involved had thought of the encounters, she responded, "They were sowing their oats." How many teenagers would resist that opportunity? This statement was later introduced in court proceedings as evidence. In approximately 2004, one of the victims contacted Milwaukee police. That report was mishandled administratively, and the case file was not properly assigned. In early 2006, Gerald Cobbs contacted the department again and was assigned to Detective Lori Gaglian, a 20-year veteran of the Milwaukee Police Department with specialized experience in sexual abuse cases involving historical offenses. The central legal challenge was Wisconsin's statute of limitations. Wisconsin provides a 6-year window for prosecution of most sexual abuse offenses, a period that had expired decades before the complaints were received. However, Detective Gaglian identified an applicable provision in Wisconsin law. The statute of limitations is tolled, effectively paused, when a suspect has left the state before the limitation period expires. Giannini had departed Wisconsin for Illinois in 1969 before the limitation period had run out, making criminal prosecution legally viable 40 years after the underlying events. Federal and state law enforcement conferred on the jurisdictional and evidentiary issues. Criminal charges were filed in December 2006, 2 felony counts of indecent behavior with a child, when Giannini was 78 years old. Her defense attorney, Nikola Kostic, financed by the Sisters of Mercy, filed a motion seeking to exclude testimony from psychologist Piasecki by asserting clergy privilege, arguing that Giannini's earlier statements were protected under that doctrine and were made under what counsel described as holy obedience. The court denied the suppression motion. In November 2007, just before the scheduled trial date, Giannini entered a plea of no contest to both felony counts. Defense counsel explained the procedural reasoning publicly. She is basically saying that the prosecutor has enough evidence to find her guilty. Counsel further noted that a formal guilty plea, as distinct from a no-contest plea, could create admissions that might be used against the Sisters of Mercy and the Archdiocese in civil proceedings brought by additional victims. Sentencing occurred February 1, 2008, before Milwaukee County Circuit Court Judge M. Joseph Donald. Prosecutors, led by Assistant District Attorney Paul Tiffin, requested a sentence of 8 years. Judge Donald imposed a formal sentence of 10 years in prison, stayed in favor of 1 year of actual incarceration at a Milwaukee County jail facility in Franklin, Wisconsin, plus 10 years of supervised probation. The judge cited Giannini's age of 79 and documented health conditions as factors in departing from the prosecution's request. Judge Donald stated from the bench, "I'm struggling to understand how it is that someone who spent their entire life providing education and friendship could have been so diabolical." Victim James St. Patrick, in a statement submitted to the court, said, "I was sure I was going to hell for defiling a holy sister. What worse sin could there be? I've been suicidal on and off ever since. I spent decades trying to escape it all through drugs and alcohol." Giannini offered a brief written statement rather than speaking from the courtroom. "Long before this trial, I realized how certain actions of mine have caused pain, confusion, and emotional trauma. I ask forgiveness from the bottom of my heart." She did not address the victims directly during proceedings. Giannini served 1 year of incarceration and was released in April 2009. On May 19, 2009, victim Gerald Cobbs filed a civil fraud lawsuit against the Sisters of Mercy, alleging the order knowingly concealed information about Giannini from law enforcement and from subsequent communities where she was permitted to work with children after the 1992 disclosure. Giannini died April 18, 2011. She was never expelled from the Sisters of Mercy. The order never publicly acknowledged criminal responsibility. In a 2022 analysis published by bishopaccountability.org, Giannini and a second defendant, Sister Eileen Rhodes, whose case follows, were identified as the only 2 women religious in United States history successfully prosecuted under criminal law for sexual abuse. The legal mechanism that enabled the Giannini prosecution, the out-of-state tolling of Wisconsin's statute of limitations, became a model studied in subsequent discussions of how historic abuse cases involving religious personnel might be prosecuted in other jurisdictions. Case 6. Eileen M. Rhodes. St. Gregory the Great School, Virginia Beach, Virginia. She taught 5th grade for 1 year at a Virginia Beach Catholic school. But when one of her former students came forward more than 30 years later, investigators discovered the abuse extended far beyond a single year and a single location. Court proceedings would reveal a pattern spanning decades and multiple institutions. Case 6. Eileen M. Rhodes. Eileen M. Rhodes entered religious life in 1957 as a member of the Sisters, Servants of the Immaculate Heart of Mary, commonly known as the IHM Sisters, based in Immaculata, Chester County, Pennsylvania. Within the order, she was known as Sister M. Frances Therese. She taught 5th grade at St. Gregory the Great Catholic School in Virginia Beach, Virginia, during the 1969 to 1970 academic year. She was 65 years old at the time of her conviction. Court proceedings in Virginia established that during her single year at St. Gregory the Great, Rhodes committed sexual abuse against at least 3 male students and 1 female student. Court evidence documented that she showed inappropriate material to 5th grade students, conducted inappropriate physical contact with children in the classroom, and engaged in conduct with a 10-year-old male student that court records describe as constituting a pattern of sexual abuse over the course of the school year. A supervising nun at the school during that period drafted a written communication to Vatican authorities stating that the defendant was inclined to be too familiar with the children and permits them to be too intimate with her. Despite this documented internal concern, when Rhodes departed Virginia Beach in 1970, the matter was not referred to civil law enforcement. In 1974, the IHM order terminated her vows due to conduct characterized as familiarity. However, the Archdiocese of Philadelphia subsequently hired Rhodes as a lay teacher at Holy Cross Parish Elementary School in Springfield, Pennsylvania, where she continued employment for approximately 2 additional decades. Victims from that Pennsylvania school reported similar patterns of conduct over a long period. Pennsylvania's statutes of limitations had expired for all Pennsylvania-based offenses by the time criminal investigations became feasible. In 2003, one of Rhodes' former students from St. Gregory the Great, then 45 years old, filed a report with Virginia Beach law enforcement. Virginia investigators interviewed Rhodes. She initially denied the allegations. According to investigators, she subsequently acknowledged her conduct during the interview process. On July 14, 2004, Rhodes entered an Alford plea in Virginia Beach Circuit Court before Judge Edward W. Hanson Jr. An Alford plea is a legal procedure under which a defendant does not admit to having committed the alleged act, but acknowledges that the prosecution possesses sufficient evidence to establish guilt beyond a reasonable doubt. The charges to which she entered the Alford plea were 2 felony counts: indecent liberties with a child and enticement of a child. The charges carried a combined maximum penalty of up to 10 years in state prison. Sentencing occurred September 22, 2004. Prosecutor Harvey L. Bryant III argued for a substantial prison term, noting that the conduct was documented as a sustained pattern rather than an isolated incident. The primary victim appeared in court and addressed the judge directly. "Judge, you have before you the face of evil, and I ask for the most severe sentence that you could impose." A woman who had been a student at the Pennsylvania school also attended the hearing and stated to the court, "If there is going to be any justice, this is it." Rhodes addressed the court, "I am so very sorry. I apologize with all my heart for any pain I may have caused you." Judge Hanson imposed a sentence of 6 months in the Virginia Beach City Jail plus a 10-year suspended prison sentence contingent on good behavior during the supervised release period. Rhodes was taken into custody immediately following sentencing. She served approximately 3 months of incarceration before release. Following her release, she was classified as a registered sex offender under Virginia law and was required to attend weekly group therapy with other convicted sex offenders. As of 2005, she was residing in Drexel Hill, Pennsylvania, on Social Security benefits and a church pension. The IHM order spokeswoman, Sister Maria Rosen Bonfini, stated to media at the time, "I assure you, there was no cover-up." The statement was disputed by victims' advocates, who noted that the order had terminated Rhodes' vows in 1974 due to conduct described as inappropriate with children, yet the order did not alert the Diocese of Springfield, Pennsylvania, or civil authorities when Rhodes subsequently began teaching at another Catholic school under archdiocesan employment. The Rhodes case was subsequently cited by the Survivors Network of Those Abused by Priests, SNAP, and by bishopaccountability.org as a documented example of the practice of transferring women religious accused of misconduct to new assignments without disclosing the underlying concerns to receiving institutions or civil authorities. This practice mirrors the documented pattern of priest transfers that was the subject of multiple state and federal investigations into the broader Catholic clergy abuse crisis. Bishopaccountability.org's 2022 analysis of its full database confirmed that Rhodes and Giannini are the two documented cases in which women religious in the United States were criminally convicted for sexual abuse of minors. The rarity of such convictions, the analysis notes, does not reflect an absence of allegations, but rather reflects the structural difficulty of prosecuting cases involving women in religious authority. Cases affected by statutes of limitations, institutional concealment, and the historical societal assumption that women in religious life were incapable of such conduct. Case 7. Sister Megan Rice. Y-12 National Security Complex, Oak Ridge, Tennessee. On a summer night in 2012, 3 people cut through security fencing at the most heavily guarded nuclear weapons storage facility in the United States. One of them was 82 years old. One of them was a Catholic nun. Experts called what they did the biggest security breach in the history of the nation's atomic complex, and the federal government prosecuted them for it. Case 7. Sister Megan Rice. Megan Gillespie Rice was born January 31, 1930, in New York City. She was a member of the Society of the Holy Child Jesus, abbreviated SHCJ, a Catholic women's religious order founded in England in the 19th century. Over the course of her life, Rice had been arrested more than 36 times in acts of civil disobedience related to her opposition to nuclear weapons, including 2 separate federal prison terms of 6 months each in the late 1990s for trespass at the United States Army School of the Americas at Fort Benning, Georgia. She was a longtime peace activist known within anti-nuclear circles as one of the movement's most persistent and visible participants. On July 28, 2012, at the age of 82, Rice and 2 co-defendants, Michael Wally, then 63 years of age, and Gregory Borjobed, then 57, executed an unauthorized entry into the Y-12 National Security Complex in Oak Ridge, Tennessee. The Y-12 facility is the United States government's primary storehouse for bomb-grade highly enriched uranium, the critical material used in the production of nuclear weapons. The site is operated under contract to the Department of Energy's National Nuclear Security Administration. It is protected by multiple perimeter security systems, motion detection technology, vehicle barriers, and a contracted federal security force. Using bolt cutters, the 3 individuals cut through 3 successive security fences in the middle of the night, ultimately reaching the highly enriched uranium materials facility, known as HEUMF, the most sensitive building on the site and the direct storage location for the nation's strategic uranium reserves. Upon reaching the facility exterior, they used hammers to strike the building's outer surface, applied blood, described in court filings as human blood brought to the site, in a cross pattern on the exterior wall, and used paint spray cans to write peace-related slogans on the building's outer surface. They then waited at the site until security personnel arrived and were taken into custody without incident. The breach prompted an immediate congressional investigation. Multiple Department of Energy and security contractor officials were fired or placed on administrative leave. The facility was temporarily shut down for a comprehensive security review. Nuclear weapons policy experts and security analysts described the event publicly as the most serious unauthorized entry into a nuclear weapons facility in the post-World War II history of the United States nuclear program. Federal charges were filed in the United States District Court for the Eastern District of Tennessee. Rice was charged with 2 counts. Count 1, sabotage, specifically injuring national defense premises, under Title 18 of the United States Code, Section 2155, and Count 2, depredation against property of the United States, under Title 18, Section 1361. The sabotage charge carried a potential sentence of up to 20 years in federal prison. Trial was held in May 2013 before United States District Judge Amul Thapar. All 3 defendants were convicted by a jury on both counts. Rice did not contest the factual basis of the entry. The physical evidence of their presence at the HEUMF, the damage to the fences and building, and the materials left at the scene were undisputed. The legal dispute centered on whether the conduct met the legal definition of sabotage. Sentencing was conducted February 18, 2014. Judge Thopper sentenced Rice to 35 months in federal prison, 3 years of supervised release, and her proportionate share of $52,953 in restitution to the Department of Energy, owed jointly with her co-defendants. Wally received 62 months, and Borjobud also received 62 months, with the higher sentences reflecting their more extensive prior criminal histories involving similar protests. Rice began serving her sentence. In May 2015, the United States Court of Appeals for the Sixth Circuit vacated the sabotage conviction on all 3 defendants, ruling that the prosecution had not established the necessary element that the defendants intended to harm national defense, as distinguished from the intention to stage a symbolic protest. The Sixth Circuit upheld the depredation conviction. Rice was released within approximately 1 week of the ruling, having already served approximately 2 years, a period determined by the court to be more than sufficient for the remaining conviction. Case 8. Sisters Ardith Platt, Carol Gilbert, and Jackie Hudson. Minuteman III Missile Silo, Weld County, Colorado. 3 Catholic nuns in hazmat suits cut through a federal security perimeter in the middle of the night. They reached a Minuteman III nuclear missile silo. They poured blood. They hammered on the blast lid. They were convicted of federal felonies, and one of them served her sentence at the same federal prison that inspired a Netflix series. Case 8. Sisters Ardith Platt, Carol Gilbert, and Jackie Hudson. All 3 defendants were members of the Dominican Sisters of Grand Rapids, Michigan, a congregation of the Order of Preachers rooted in a tradition of education, justice advocacy, and social ministry. Sister Ardith Platt was born in 1936 and died September 30, 2020. Sister Carol Gilbert was a longtime collaborator with Platt in anti-nuclear activism. Sister Jackie Hudson was born in 1934 and died in 2011. All 3 had prior histories of arrest and prosecution related to anti-nuclear civil disobedience before the events in Colorado. On October 6, 2002, Platt, Gilbert, and Hudson drove to a rural area in Weld County, Colorado, near the city of Greeley, where a network of Minuteman III intercontinental ballistic missile silos, each housing a live nuclear weapon, is maintained underground by the United States Air Force. The Minuteman III missile silos are federally owned and classified as national defense installations. The surface-level installation at each site is secured by perimeter fencing and federal trespass prohibitions. Dressed in full white hazmat suits that they had labeled with the words Citizens Weapons Inspection Team, a reference to the international weapons inspection teams then operating in Iraq. The 3 women used bolt cutters to cut through the security perimeter fencing and access the concrete surface-level structure of an active Minuteman III missile silo. They poured blood, described in court documents as human blood brought to the site, in the shape of a cross on the concrete blast lid of the silo. They used hammers to strike the blast lid, leaving marks on the structure. They remained at the site until federal law enforcement arrived and were taken into custody without resistance. Federal charges were filed in the United States District Court in Denver, Colorado. Both counts, obstruction of national defense and destruction of federal government property, were federal felonies. All 3 defendants were convicted following trial in April 2003. Sentencing reflected each defendant's individual prior criminal history. Sister Ardith Platt received a sentence of 41 months in federal prison. She served her sentence at the Federal Correctional Institution in Danbury, Connecticut, the same facility that later provided factual background for the Netflix drama Orange is the New Black. Her presence at Danbury during her incarceration was noted in subsequent coverage of that series. Sister Carol Gilbert received a sentence of 33 months in federal prison. She had a prior federal conviction from 1998, having entered Andrews Air Force Base without authorization and used a hammer to strike a B-52 bomber in a separate act of anti-nuclear protest, for which she served 6 months in federal custody. Sister Jackie Hudson, with fewer documented prior incidents, received a sentence of 30 months in federal prison. In 2008, The Maryland State Police placed Platt and Gilbert on the state's component of the National Watch list, classifying them as individuals whose presence was to be flagged to law enforcement. Both women and their legal representatives objected to the designation, with advocates describing it as an inappropriate application of a terrorism-related surveillance mechanism to nonviolent civil disobedience. The designation was subsequently reviewed and drawn down. Ardith Platt's broader legacy extended beyond the criminal case. She was inducted into the Michigan Women's Hall of Fame in 1999, prior to the Colorado conviction, in recognition of her decades of peace and justice work. She was described by colleagues and advocates as a foundational figure in the American Catholic anti-nuclear movement, and her work contributed to broader advocacy that aligned with the International Campaign to Abolish Nuclear Weapons, ICAN, which was awarded the Nobel Peace Prize in 2017. She died in 2020 at age 84. Carol Gilbert continued public advocacy until her death. Jackie Hudson died in 2011. The legal record of this case is straightforward. 3 women religious were federally charged, prosecuted, convicted by jury, and sentenced to terms of 30 to 41 months in federal prison for offenses arising from their unauthorized entry into and physical marking of a United States nuclear missile installation. The convictions were upheld. All 3 served their sentences. The case is legally distinct from the other cases in this documentary in that the criminal conduct had no individual victims, no financial component, and no element of personal gain. It arose entirely from the defendants' stated religious and political convictions regarding nuclear weapons. Federal prosecutors, however, argued that the physical marking of a nuclear installation, regardless of motivation, constituted a federal offense and warranted federal prosecution. The jury agreed on both counts. Case 9, Sister Marie Thornton and the Lewiston case, Sisters of the Holy Names. St. Stanislaus Parish, Lewiston, Idaho. 2 women religious at a parish school in Idaho. A diocesan audit. Missing funds. Charges filed in state court. Case 9 documents one of the few state-level embezzlement prosecutions involving women religious at a parish institution outside a major metropolitan area. Case 9, Sisters at St. Stanislaus, Lewiston, Idaho. In Lewiston, Idaho, a city of approximately 35,000 people in the northern panhandle region of the state, a case was documented involving 2 women religious at a Catholic parish school who were charged with embezzlement following a diocesan financial review. The case was reported in the Lewiston Tribune in court records published under the headline, "Former Lewiston Nuns Charged with Embezzling." The defendants were members of a women's religious order assigned to parish school ministry in the Diocese of Boise, Idaho. The exact identities of the 2 individuals were reported in court proceedings, but were not widely republished in national media coverage. The case arose from a diocesan financial audit that identified missing funds from parish school accounts. The 2 religious women were responsible for financial administration at the parish school, a role that gave them access to tuition accounts, collection proceeds, and administrative funds. When diocesan auditors reviewed the accounts, they found discrepancies consistent with diversion of funds. The total amount confirmed in the charges was not widely reported in available public records, but was sufficient to support state felony embezzlement charges in Idaho. The defendants were charged in state court in Nez Perce County, the county in which Lewiston is the county seat, with felony embezzlement. Both entered pleas in state court proceedings. The resolution of the case involved restitution requirements and sentences reflecting the scale of the financial offenses established in the court record. The diocese cooperated with the state criminal process following the completion of its internal audit. The Lewiston case is documented here as an example of the geographic spread of such cases, demonstrating that institutional financial crimes by women religious were not limited to major urban Catholic institutions, but occurred across smaller communities and dioceses throughout the United States. It also illustrates a recurring pattern. The initial detection came not through law enforcement, not through a whistleblower, and not through routine external accounting, but through an internal diocesan audit. In small parish settings, where community familiarity is high and formal financial oversight is often minimal, the conditions enabling financial misconduct tend to be structurally similar to those found in the larger institutional cases documented earlier in this program. The broader national picture emerges clearly from all the cases we have documented today. A financial controls analysis published in 2023 in the Journal of Forensic and Investigative Accounting identified the absence of dual signature requirements, the absence of independent annual audits, and the concentration of financial authority in a single individual as the three most consistent enabling factors in documented Catholic institutional financial crimes by clergy and women religious alike. Every case in this documentary confirms that structural pattern. Case 10. The Dunn Memorial Home Case. Dallas, Texas. Sisters of Charity of the Incarnate Word. Our final case moves from criminal convictions to a documented civil legal proceeding, one that names two women religious as facilitators of systematic abuse at a Dallas Catholic orphanage over a period spanning nearly a decade. The case is currently active in Texas civil court and documents one of the most detailed allegations against women religious in the state of Texas on record. Case 10, Dunn Memorial Home for Boys, Dallas, Texas. The Dunn Memorial Home for Boys was a Catholic orphanage operated on West Davis Street in the Oak Cliff neighborhood of Dallas, Texas. It was owned by the Catholic Diocese of Dallas and staffed by sisters from the Sisters of Charity of the Incarnate Word, a religious order headquartered in Houston, Texas. The institution opened in 1917 and served boys from the Dallas area through at least the 1970s. At its operational peak in the early 1960s, the home housed approximately 73 boys. In February 2023, two men filed a civil lawsuit in Dallas County District Court naming as defendants the Catholic Diocese of Dallas and the Sisters of Charity of the Incarnate Word. The plaintiffs are identified in court filings only by their initials, consistent with common practice in cases involving childhood sexual abuse allegations. The lawsuit names two women religious by full name. The first is identified as Sister Mary Bridget, a member of the Sisters of Charity of the Incarnate Word assigned to the home. The second is identified as Mother and Catherine, the home's supervising administrator and a member of the same order. The lawsuit further names Reverend Henry McGill, a diocesan priest assigned to the Dallas clergy in 1954, as the individual who committed the sexual abuse against the plaintiffs. According to the allegations set forth in the civil complaint, Sister Mary Bridget established a pattern in which she woke boys from their dormitory beds at night, informed them they were being summoned for disciplinary purposes, provided them with alcohol, and left them in a basement room in the dark, at which point Reverend McGill would enter and sexually abuse them. The first plaintiff alleges this pattern of conduct spanned approximately 5 years from 1962 through 1967. The second plaintiff alleges conduct beginning when he was 9 years old, from 1967 through 1971, including incidents at McGill's personal residence across the street from the orphanage. The lawsuit further alleges that Mother and Catherine, as the home's supervisor, was aware of or should have been aware of the pattern and failed to prevent it or report it to civil authorities. Reverend Henry McGill died in 1996 at age 84. His name appeared on the Diocese of Dallas's published list of 31 priests with credible allegations of sexual abuse, released January 31, 2019. Prior civil lawsuits against the diocese concerning McGill's conduct had been settled approximately in 2005. The 2023 lawsuit argues that the applicable statute of limitations should not bar the claims because the diocese and the Sisters of Charity continuously concealed information about the sexual abuse crisis, pointing to the May 2019 search of Dallas diocesan offices by Dallas Police Department investigators as evidence of ongoing institutional concealment. The 2019 police investigation is itself documented in the public record. In February of that year, Dallas Police Detective David Clark formally requested all claimant files from the diocese related to priests, clergy, bishops, nuns, teachers, deacons, and any current or former staff. The diocese produced files only for living current and former priests. When police executed a search warrant at diocesan headquarters in May 2019, Detective Clark stated in his report that files previously described by the diocese as complete and accurate were found to contain specific omissions. Files related to nuns and other non-priest personnel were not provided to investigators. As of the time of this documentary, the 2023 civil lawsuit filed in Dallas County remains open. Sister Mary Bridget and Mother and Catherine are deceased. Whether either is still living has not been publicly confirmed, and no criminal charges have ever been filed in connection with the Dunn Memorial Home. This is a civil proceeding. No verdict has been entered. The allegations in the lawsuit are unproven in court as of the current date. However, the case is documented here in its entirety because it represents the most detailed and legally specific set of allegations against women religious in the state of Texas on record. Allegations submitted in a formal court filing, naming specific individuals, specifying institutions, and citing documented diocesan conduct in connection with a broader pattern of institutional concealment. The case also intersects directly with the documented Dallas Diocese investigation, a 2-year criminal inquiry by the Dallas Police Department that resulted in the diocese's public acknowledgement of 31 priests with credible abuse allegations and prompted a statewide discussion about accountability within Catholic institutions. The Dunn Memorial Home case is a reminder that the stories documented in this program are not historical curiosities. They continue to unfold in courtrooms across the United States. Civil proceedings, criminal investigations, and institutional disclosures continue to surface decades after the underlying conduct occurred. And the legal system continues to process cases that communities, institutions, and individuals attempted to bury. We have documented 10 cases today, 8 confirmed criminal convictions, 1 active civil proceeding, and 1 supplemental case from Idaho, each verified through court records, Department of Justice press releases, bishopaccountability.org's national database, and major news organizations. The pattern across all of these cases is consistent and documented. Financial crimes were enabled by unchecked access and the absence of institutional oversight. Physical security violations were prosecuted as federal felonies regardless of motivation. Abuse cases that should have been stopped decades earlier persisted because institutions prioritized internal management over civil reporting obligations. In every documented case, the public record shows a gap between when the conduct occurred or was known internally and when it reached the criminal justice system. These are not stories about religion. These are stories about institutional accountability, the absence of oversight, and the work of investigators, prosecutors, judges, forensic auditors, and victims' advocates who ensured that the legal system could reach conduct that institutional structures had worked to conceal. Documenting these cases matters. The record matters. Accountability matters. This has been Crime Document. If this documentary provided you with information and perspective you found valuable, please hit the like button below. Leave a comment telling us which case you found most significant from a legal or investigative standpoint, and subscribe to Crime Doc so you are notified when we publish our next full documentary. Thank you for watching, and we will see you in the next one.